All right. Well, thank you all for joining today for EWA's webinar, FCC Compliance Requirements for Ownership Transactions. Before we begin, I'd like to go over a few housekeeping rules. If you could move the slide forward, please. Thank you. Thank you. Today's webinar is being recorded and will be made available to you following the session. Questions will be taken throughout, but will be answered at the end of the session. To pose your question, put it into the Q&A box, which is at the bottom of your screen, and we will address them at the end. Today's presenters are Robin Cohen, EWA President and CEO, and Liz Sachs, EWA Regulatory Counsel. Both presenters have a vast amount of experience in dealing with ownership transactions and FCC compliance and have a great deal of experience to share with you today. With that, Robin, please take it away.
Thank you, Andrea. So I would say over the past few years, but most importantly, over the past 6 months, Liz and I have been getting a lot of phone calls from customers and clients related to assignments of authorizations and transfers of control and what the FCC rules are associated with each. And we realized that this was a webinar that has been a long time in the making to inform everybody, because we realize that there's a lot of folks within the private wireless industry that are not aware of the FCC rules. And this is the specific rule within Part 1 of 1.948A that if you see basically the underlined section, it requires prior FCC approval. And what we're going to go over is the FCC rules and use cases that we can share with you, the different FCC requirements associated with that. And I guess to start out, Liz, this is applicable to the private wireless industry in general, but are there any exceptions to this rule related to prior approval that would be applicable?
Yeah, and let me say, one of the reasons we wanted to do this webinar is because a number of those questions came, unfortunately, after the transactions had already been consummated without prior FCC approval. So that suggested that this was an opportune time. And I don't think I can be accused of ageism about this, but I'm guessing that a number of people on this call are starting to do some planning for succession. And that's going to involve potentially signing licenses or transferring control of your licenses. So you need to understand what needs to be done. Some years ago, Congress, this all comes from the Communications Act. This is not an FCC decision that you have to go through this process. But some years ago, the commission adopted some rules that said that for certain common carrier licenses, you don't need prior approval. You can just file a notification within 30 days after the fact. But that does not apply to Part 90 licenses, not to any of the Part 90 licenses. So people on this call need to be aware you have to get prior approval from the FCC. Good news is, as we'll discuss, it doesn't take long, but you have to file.
Right. You know, and also to that, Liz, there's been a lot of consolidation in our industry. And where there's buying of companies, it's not even just buying an asset like a FCC license, it's buying of companies, it's merging of companies, it's
Right.
reorganizations within companies. And so those are things that we're going to be discussing, you know, over the next few slides. These are the different types of transactions that we're going to talk about over the next half hour or so. Assignment of authorizations. Again, it's purchases of licenses only. Transfers of control is where you are actually buying another company and, you know, basically purchasing the ownership of that company. I don't know, Liz, if you want to add anything, because I know there's been a lot of confusion related to assignments and transfers of control.
Just a fundamental rule. I think most people understand that you need prior FCC approval if a new entity is going to be holding the license and you do an assignment, and it's a different FRN, it's a different tax ID, it's a different everything. And you could be purchasing licenses and lots of other assets too, but you're acquiring specific assets. What confuses people is a transfer of control where the FRN stays the same, the EIN stays the same, but someone other than the original owner or the owner at the time that the license was acquired is going to take control of it, meaning greater than 50% or greater than 50% of the ownership. And I think it confuses people because no Part 90 licenses, you don't have to tell the commission who owned the stock or the partnership or whatever when you got the license. So I think it's not intuitive that you have to tell them when that ownership that you never disclosed to begin with changes. But again, it's a product of the Communications Act.
Right, right. In addition to that, so these are terms that are used in the FCC rules as it relates to internal and external assignments and transfer of control, and they use the word pro forma. So whether it's pro forma or non-pro forma, so we're going to discuss that. We're also going to discuss involuntary transactions. And again, on the FCC forms and also in the rules, there's voluntary, which are, you know, your everyday assignments and transfer of control type transactions. And then there's also the involuntary side, and we'll get into those as to what the definition is. And there's also administrative updates, and what the difference is between what the commission uses as an administrative update versus when you should be filing an assignment and or transfer of control. Do you want to discuss the pro forma side?
Yeah. I mean, pro forma really means that the ultimate ownership of the entity controlling the license doesn't change. I mean, pro forma comes up typically in a larger organization where you have, for example, a holding company, and then you have a bunch of subs. And those subs hold the license or can hold the licenses. They don't have to, but they can. And so when you move assets from one subsidiary to another, internally on the books of the company, and the assets get moved and the licenses move along with them. As far as the commission is concerned, that's pro forma because the ultimate ownership, the holding company, has not changed. A transfer of control is typically when a new subsidiary gets created and gets put between the parent company and a subsidiary that holds a license. So now, again, it's not that the ultimate ownership has changed, but the immediate ownership has. And unfortunately, both of these, just like you were doing with the third party, they require prior FCC approval. Now, there is a pending petition filed by, I think it was CTIA and somebody else, US Telecom, saying, this is ridiculous. Why do we have to get approval if there's no change in the ultimate ownership? And there are certain licenses issued by the FCC, not our licenses, not wireless licenses, where you can do that without getting prior approval. But that petition was filed about 2 years ago, maybe more now, and the commission has never done anything with it, even though all of the comments came in and said, great idea, let's get rid of this, it would save time and energy. But when you're doing things internally within a larger organization, you need to just check and make sure that it doesn't constitute a pro forma assignment or transfer. The good news, and we'll talk about this, most of these applications that you file, particularly for Part 90 licenses, they grant overnight.
Right.
You know, as long as you've done some due diligence and made sure that the licenses are all in order, they get automatic approval. So it doesn't slow the transaction or the action, but you need to check with somebody if you're moving assets around within an organization or if new subs are being created.
And again, the common theme that you're going to hear us like trying to drive home through this entire presentation is it's prior FCC approval, whether it's internal restructurings or if it's non-pro forma, which we're going to get into. So non-pro forma is the example for an assignment of authorization, again, is where you're only acquiring the FCC licenses from a company. So if licensee A is selling to licensee B, it's an assignment of authorization application from A to B. And again, like Liz said, more often than not, routinely, it is approved by the FCC overnight, but does require prior FCC approval. And a transfer of control is when the licensee, the entity, the parent company of that licensee is actually being bought by a completely different company. That's like a prime example of a non-pro forma transfer of control. So you still have to get, again, prior FCC approval, and you have to explain what Liz and I have learned in a public interest statement attached to any of these applications, explaining what the new structure, what the transaction, it's a description of the transaction. So the FCC knows who the final party is going to be that's going to be owning the assets.
But, you know, the transfer of control is even if you have, as many Part 90 licensees have, the licenses were acquired in the name of an entity, and the person who created the company and built it up typically had controlling ownership of the company, had controlling ownership of the stock or the partnership or whatever it is. And now that person wants to sell or wants to retire. And even if they are selling to family members that didn't previously have a controlling interest in that company, that's a transfer of control. It doesn't have to be to some third party that just showed up at your door one day and wanted to buy you. It can be if you're selling to employees, if you're selling to your kids, that is a transfer of control in the commission's language, and it requires prior approval.
That is a key piece that there seems to be a lot of confusion on within our industry, because there are a lot of family-owned businesses. And again, even if it's not family-owned and the current owner wants to sell to employees, you still have to get prior FCC approval of that transaction. And, you know, even if the percentages are changing, if the current owner is 100% and they decide that they want to start taking a step back and they're going to sell a portion of it, you know, 52% of it to employees, that still requires approval of the FCC.
Right. 50% is the key
Is the
thing
key
to think
number.
about.
Yes.
Yeah.
Involuntary transactions.
What a nice way to put it.
Yeah. So, you know, these are two examples, one of which we run into more often than not in the private wireless industry is related to if there's a death of a licensee. So if the license is held by an individual and that person passes away, there's an FCC rule, 1.948G, that requires an application to be filed for the involuntary assignment from the deceased licensee to another individual or organization. And it's called involuntary because obviously the deceased can't sign on behalf of themselves on the application. And the unfortunate part is the rule requires applications to be filed within 30 days of the event. And the last thing on people's minds when your loved one passes away is like, oh, I have to file an involuntary assignment or transfer of control from, mom or dad to X, Y, and Z. And the good news is that the FCC, I think, also realizes this 30 days is a bit crazy. It's one of those ancient rules that's in there. And they do routinely grant these applications. They do unfortunately require a copy of the death certificate to be included with the application, which is a little bit morbid, but it actually shows what the date of death is, so that way it corresponds with the actual application and certain questions that you're required to answer on it.
And it's not even if the license is held by an individual. If the stock ownership is held by somebody who dies.
Right.
That is also an involuntary transaction, and you need to file. I mean, I think 4 years was the latest that I've ever actually had to file for an involuntary transfer. And I would say up until now, it's never been an issue. I think you have to request a waiver, but it's standard, they
Right.
grant it. But that was with a person who worked at the FCC for a long time, and it was just never an issue with that person.
Right.
That person has now retired, like
Right.
so many have, and I can't tell you that the new person handling these is going to be as flexible. I just don't know, haven't had to do one. I mean, in the end, they're going to approve it. It's not a question of whether they approve it or not. It's whether they want to slap your hand for delaying it for a long
Right.
time, but.
Right.
I mean, 30 days is unrealistic in that.
It is.
You don't even know.
You don't even have the estate established,
Right. You don't even
within
know who
30
it's supposed to go
days.
to with 30
Right,
days.
right. So I think that's why they're a bit lenient on that rule.
Right.
But it is still a requirement. And, even if there's interim steps, it could cause, multiple filings
Yeah.
as a result of it.
Often the case.
Bankruptcy is another good example of involuntary transactions that has occurred in our space as well. And, it gets complicated, but it's literally taking it from the licensee into like the debtor in possession. And then when an entity comes out of debtor in possession, it comes out of
Whoever buys
bankruptcy, whoever buys it, there's another set of applications that has to go through. But the bankruptcy is another good example of an involuntary transaction outside of a death of a licensee or a primary owner. Do you have anything else you wanted to add to that?
Nope. I mean, I think the reality is, as we all know, the FCC has no idea when these things happen. They operate on the honor system because, it's like constructing a tower or, taking a system out of operation. They don't know unless somebody tells them.
Right.
So, it's not as though there's somebody at the FCC looking for these things. But the issue arises typically when you go to sell. And even the most basic purchase agreements, whether it's stock purchase or asset purchase, they want you to make representations that everything has been done in accordance with the rules and that your licenses are good and there are no violations. And so, a lot of people say, well, why do I even have to tell them? They'll never know. And I say, yeah, well, that's true, but you want to sign a document representing that you're in compliance with all the rules, and when you know you're not, I mean, that's when it really becomes more of an issue.
So just one thing I wanted to emphasize as it relates to like the prior FCC approval piece of it. We've had I know I've had a lot of questions as to like, what does that mean? So if you're working on a business transaction where, you're planning on selling, let's say just for simplicity's sake, you're selling some of your licenses to another entity. And prior FCC approval means, so when you're working on that contract or that agreement, you should have language in there that it's part of a closing condition that you already have FCC approval to before you can actually close the transaction. And closing the transaction is typically when, the money exchanges hands and you sign closing documents,
Right.
Closing the overall transaction. So I just wanted to clarify that that's a lot of, what why you should have that language in your agreements, why you should abide by it, and what it means, because a lot of people are just like, prior to what, so that's been a question that EWA has been getting a lot of.
And it's simple. The application process is simple.
It is.
It's not complicated. You just have to do it.
It is. So this is just an overview of what the application process is. So the FCC Form 603 is the form that is used for the assignments and transfers control, whether it be pro forma or non-pro forma. The FCC Form 602 is an ownership form. And this is where Liz was talking about it earlier, that there's only, certain licensees in our space that are required to have a 602 form on file with the commission, which identifies what the ownership structure is of your company.
It's only if you have auction spectrum. Our
Correct.
22 CP licenses, you had to have filed an ownership report when you got it,
Right.
and it needs to be updated. If there's a transfer of control and the new owner, if somebody buys your CP licenses, they've got to file a 602.
Right. So if you don't have, the geographic market licenses
It's only
like that,
auction licenses.
then you're not required to. And that's goes back to what Liz was saying earlier, is that more often than not in our space, the FCC has absolutely no idea what the structure of your company is.
Right.
You're not like, an AT&T, Verizon, T-Mobile that, everything's public like that. But, we do have a lot of large
Right.
business enterprises in our space, and private carriers that you may be public. And the one thing I want to share, because this is something that happened recently, the FCC actually uses Google to see if you are actually telling the truth in your application. So if there's press releases, this is something that I've been emphasizing a lot with folks recently, is if there's a press release that says when a transaction occurred and it's pretty clear by the press release. Another big reason why you want to make sure that everything's truthful and accurate in your application and in the description of the transaction and such. Like Liz says, FCC issues the approval. I haven't seen many, if any, in our world that they haven't approved it. It's more of the after effects that if you do not get prior FCC approval and you're seeking a waiver, a year or two after a transaction, and we're going to get into that as it relates to the risks and what could occur with that here in a little bit. And then the final piece of the application process, and this is the most important, and there have been some entities that actually have forgotten about this key piece, is notifying the commission that you consummated, that you closed the transaction, and they want a date. So again, that date should be after the FCC approval. Otherwise you need a waiver and all that good stuff. But this is a key piece, especially with, assignments where the licensee name changes from the current licensee to the buyer. When you consummate it, it'll flip into the new entity's name,
That's what
typically
triggers it.
overnight. So
What I've never understood is the buyer has to file the consummation notification.
right.
It seems to
It's
me
not
more
there- it's not
logical
theirs
that
yet.
the seller would file,
Right.
say, yes, we have consummated,
Right.
I've been paid. The buyer
Right.
has to do that.
Yeah.
It's not an option.
Yeah, it's not, I don't think the
Never
FCC
made
thought that
sense to
one.
me, but
I don't think they thought that one through.
yeah.
Non-compliance risks. So Liz, you want to talk about what happens if you do not receive prior FCC approval and what the potential FCC actions are on that?
The question is, Robin gets this question, I get this question. Now somebody realizes they didn't get prior approval. What do you do? The right answer is you self-report it to the FCC. You file an application for an STA, because if you haven't gone through the process of getting FCC approval, you don't have valid authority to operate those facilities. And what you should do is get an STA so that you are now recognized as the licensee, and then file an application to do the assignment or the transfer with a waiver request with a mea culpa, and so sorry, messed up, learned our lesson, et cetera, et cetera. I've never seen an instance where the commission doesn't grant the application. I mean, unless you disclose that you're owned by some Chinese company, but other than that, they'll grant the application. But the issue becomes, will they send that information to their enforcement bureau, which has the right to assess fines? And one of the reasons you want to, if you're going to disclose it to the commission, the sooner the better, and get an STA, because once you have an STA, now you're legally operating again. And so, the time that they can assess you for forfeiture is cut off. I mean, I've never seen them terminate a license, but they of course have the authority to do that but they'd have to go through a hearing actually to do it.
Okay.
To say that you're not qualified to hold a license. We have seen, people say, well, how often do they send it to the Enforcement Bureau? And the answer is, it's not consistent. There have been periods where lots of stuff got sent to the Enforcement Bureau. Then you go through periods where almost nothing gets sent to the Enforcement Bureau. And I think a lot of it depends on whether the Enforcement Bureau says to the operating bureaus, hey, we're totally jammed up, only give us your worst cases. I don't know that for a fact, but I suspect that there is some of that communication. I've never had something go to the Enforcement Bureau for like a single call sign or, maybe
So if there's a lot of call signs,
it's just much more likely. And if there are multiple transactions, if somebody comes in and says, oh my gosh, I didn't really understand this. And I, bought these 2 companies and there were 4 call signs. And then I had another instance and there were another 3 call signs. That's more likely to go to the Enforcement Bureau. But will it go? I would never tell somebody it will or it won't, because I just don't know for sure. And if they want to fine you, they can, and the fines can be very substantial. I mean, we've seen fines for what I thought were pretty inconsequential matters that were the largest one I saw was $300,000, almost $300,000. It was crazy. It was for a private company, just didn't understand, not providing commercial service. And I think they filed an appeal and a bunch of us filed and said, yeah, that's crazy talk.
so, and it's based off of how many days you're not in compliance and
it's
like how big
based-
of a transaction it is too,
Well,
right?
it's also based on ability to pay. That is one of the factors that the commission can take into consideration when they decide how much they are going to fine you. So bigger companies with bigger balance sheets are likely to get bigger fines than small companies.
To use them as an example.
Yeah, well, just because
Yeah.
that's what it says. I mean, that Congress came up with the factors and that's one of the factors. So yeah, it's just that's the reality.
So related to consent decrees and compliance manuals, do you think that it's helpful for someone to, when filing the transaction after the fact, do you think it's helpful for folks to actually prepare a compliance manual and tell the commission up front, we now have a compliance manual, we have a compliance officer that understands the rules.
I don't know.
Do you think that helps at all, or?
I don't know. If the commission finds out that there've been violations, either because you've self-reported it or because somebody else reports it or because they stumble upon it, there are really 2 avenues. One is a consent decree where you don't fight the commission on the fact that there has been a violation and you negotiate what the terms are going to be, and it's basically how much you're going to pay, because the rest of the terms are all really very standard. In some cases, people don't think that they should be assessed any kind of fine, or they think they've got a good explanation for why it happened and they don't want to enter into a consent decree. In that case, you get into an issue with the FCC where you file documents and they can issue a notice of apparent liability for forfeiture, and you can come back and say, oh, I think that's ridiculous and it should be this amount. In my experience, but this is very personal and I'm not sure that every lawyer would agree with me, I advise clients, do a consent decree. We know what it looks like. It's faster. It's defined. You can negotiate the dollars some. You can negotiate the time some. And what they end up doing, it's very consistent. You have to have a compliance officer, like Robin said, you have to have a compliance manual. You have to tell them that, yes, as new people join the company, people who are, trying to think of there's a term, something employees, that they're going to be educated in the commission's requirements, and you have to file typically a report at 6 months and then at a year, in the second year and a third year, confirming to the commission that you've been operating in compliance with their rules and you don't have anything to report. The reports are pretty boilerplate. They don't take a lot of time. It's not a big effort, as long as you can report accurately that you've been in compliance with the commission's rules. Do I think that affirmatively telling them that you've got that you now have a compliance officer and a compliance manual will cause them not to send it to the Enforcement Bureau? I don't know. I just don't know. Can't hurt.
We've also seen where, some applications, when they approve them, they put a special condition on them saying that they could be subject to enforcement.
Oh, yeah.
And then there's some applications that they don't. So that kind of goes to Liz's, what she was just saying a few minutes ago is it's inconsistent. And, we're not entirely sure what the determining factor is. But the common theme is that you need to be truthful and
Right.
get it taken care of, and you just got to hope for the best.
Right.
Administrative updates. So there's confusion in this as well. So the FCC's application, the ULS, allows administrative updates, and that's in the form of an FCC Form 601 that's required. And when you go in, administrative updates are typically related to like mailing addresses, phone numbers, secondary contacts, things like that. No name change, like a name change can occur, but it's only if the entity type structure didn't change, the tax ID number didn't change, there was no change in ownership. So using it as an example, say it's tax ID number 12345, and the corporation decided that it was just going to change it from WABC Corporation to WABCD Corporation. And the tax ID number didn't change and structure didn't change or anything like that. That is identified as a name change. And this is when you would file the 601 form. And that would not be an assignment or a transfer of control, correct?
But for reasons I've never understood, and I think it has to do only with the physical way we file applications and how you check the boxes. Even there are many states where you can change your corporate entity, for example, from an LLC to a corporation, or other changes from an LLP. And under state law, your tax ID does not change. It's the same legal entity. But under FCC law, if you change that entity type, it is still a pro forma assignment, because you're changing the box you check on the ULS application. And that has tripped up many people in the past, because they say, well, my tax ID didn't change.
Right.
I mean, I'm the same legal entity according to state law. And the answer is, well, yep, that works in the state, but doesn't work at the FCC.
Well, and I remember when I was at Sprint and in Excel prior to that, there were at least like 80 entities that they converted from a corporation to an LLC. And, that all those applications that had to be filed with it. So that's just something to keep in mind. That's important.
It doesn't happen often, but it does happen. And it often is people, if you're dealing with, local councils who may be great experts in state law, they say, well, there's no change there, so nothing to do. The answer is, well, according to the FCC, unfortunately, there is.
So another piece that we wanted to share too, that we don't have up on the slide, is the FCC application processing fees that they charge for these types of applications, assignments, and administrative updates don't have a fee. That's the one difference. But anything with an assignment or transfer control, pro forma, non-pro forma, they do have FCC fees. And the good news is that, so EWA filed comments on it, was it a few years ago? I don't even remember.
Yes.
But it was something that was pending at the commission for a while, and they adopted about a year and a half ago or so. And you used to get charged per call sign, like $50 per call sign, and there was no cap, there was no maximum. And that adds up. Like, trust me, like when I was at Sprint, like with 50,000 licenses, we would get charged $50 a call sign and have to pay like hundreds of thousands, sometimes, $1 million just to be able to change from an LLC, corporation to an LLC.
Right.
Now it's the first 5 call signs, I believe. Is it 3 to 5?
10,
Something like that.
Anyway,
It's minimal.
Periodically, the commission puts out a public notice and says, oh, we're gonna change our filing fees, or what the regulatory fees, I guess they call them. And we took that opportunity to say, this is ridiculous. When you have site-based licensing,
Right.
why are you penalizing us for the fact that you have site-based licensing in these services? I mean, if I'm a cellular carrier, I may have 8 licenses. If I'm an equivalent size Part 90 licensee, I may have 200 licenses. Could you make me get them that way?
Right.
And they said, yeah, all right, that seems to make sense.
Yeah.
Finally.
Yeah. So the FCC processing fees are minimal.
Right.
But they do get tagged onto the assignments and transfers of control.
Right.
All right. This is the fun part. Questions. Andrea, do we have any questions in the chat room?
We do, thank you. And to all of you, if you have a question, please put it into the Q&A box, which is at the bottom of your screen. And I'm going to start with our questions. I'm creating an ESOP within my company with the employees obtaining 30%. Does this require notification to the FCC?
If there is somebody who held more than 70% before and is now going to continue to hold 70%, is not a transfer of control. It's 50% is the defining one. So 30%, no, there's no requirement.
Okay. Let me see. I've got another one. It's how far advanced a client needs to do assignment or transfer control before renewal.
So I'll
So could
take that
you
one.
wait until renewal?
No. So I think also just part of the due diligence process, like if you're the buyer, you want to make sure that, licenses are valid, stay valid in an active status, but renewals should be filed in advance. You can file them while the assignment or transfer of control is pending at the FCC. But you need to make sure that the licenses stay valid. And to do so, you need to make sure that the renewals get filed timely. And it's not going to hold up your transaction by no means.
Okay.
The FCC will actually question why, this license expired, and they'll actually remove it. And then that license doesn't get transferred or assigned. So your buyer might be a little upset if that was not included.
And just one thing to remember, if it's an assignment and you're buying assets, you can take some licenses and leave others behind. But if it's a transfer of control, you get everything that entity had. You can't pick and choose which licenses you are acquiring. Right. And so if there are licenses that have issues with them, they need to be canceled or fixed before you file.
Right.
Because you can't just peel them off in the transfer of control process.
The other thing to add to that I want to include is, the seller, the current licensee, can continue operating under normal course of business, meaning if you're still needing to file applications, whether they be new or modifications, but using new as the example, you can continue doing that. And typically you handle it in the description of the transaction that gets attached to it, saying that you want to make sure that any pending applications that are filed, like while the transaction is pending before the FCC for approval, that those automatically get included. And sometimes the FCC may ask you if there's a large volume, they may ask you to amend the application to include any new grants associated with it. I don't know if you want to add anything to
No, I
that.
think that's right.
Okay.
Okay. How much notification does the FCC require for the transfer of ownership?
As we said, most of them get granted overnight, but there's never a guarantee of that. I mean, one of the things you always want to do for assignments and transfers is do some due diligence on the licenses themselves. Make sure that there are no call signs that still have wideband emissions, if that's an issue. Make sure that there are no missing construction dates, if that's an issue. Just need to go through the licenses, because any one of those things, even if only a single call sign in a whole bunch of call signs, it'll take you off the overnight approval process. And now you got to wait for them to process the application. So you just need to do some very basic due diligence in advance. Maybe make sure that they're not in red light status.
And, our advice is, just make sure that you're giving yourself enough time. While yes, it may get approved overnight, file it. I tell people, as soon as as soon as the contract gets signed, like even some people are concerned about, confidentiality and things like that. And you certainly have to take that into consideration, of course. But if that's like not a concern, and let's say it's a simple transaction where you're just assigning, a few licenses from, to another company, and you sign the contract and say you don't want to close until the parties don't want to close until like November, you don't have to file it now, but you definitely need to file it before November. So I would say if there's no concerns about confidentiality, go ahead and file it. And you have 180 days from FCC approval to actually close it / consummate it. So it's just better to be proactive about it and try to get it on file as soon as you can.
Okay, thank you. For involuntary transfers, do powers of attorney play a part in being able to sign for the deceased?
No, I mean, the commission understands the deceased is deceased.
Right.
So when you have an involuntary transfer, you file it with a death certificate and typically with a document that shows who now has authority to speak for the licensee. And that person is the electronic signatory. I mean, whether it's
It could be the
trust,
state, right?
State, I mean, wherever it goes, which is why so few of them could ever be filed within 30 days, because you typically don't have a document that says who is authorized now to speak for this estate within 30 days. Right. But it's not a power of attorney. It's whoever, it's the estate process. So whoever your estate attorney tells you is the person, who is authorized to get it, you get a document from them, not from the attorney, but from the state. That's what you file with the application.
Okay, thank you. Is there any specific spectrum, for example, T-band, 800 megahertz, or BEAs that are not transferable? Or is all spectrum license transferable?
I mean, the only time I can think where you can't transfer it is, for example, the original 3.5 licenses that were issued, 3.65 to 400, whatever it was, and the commission then expanded it, and they weren't issuing new licenses, and I don't think they would let them be transferred. I think their feeling was that I'm pretty sure I had that situation where somebody tried to transfer one of those licenses, but it was the context of a whole band repurposing. Other than that, I can't think of a license that cannot be transferred.
Yeah.
With prior approval.
Is there a limit to the number of call signs that can be assigned on an application?
Nope.
No. I will share, again, this goes back to my Sprint days, because we thought that we, like with transfer control. So when Sprint bought Nextel, well, they called it a merger of equals, but whatever, there were a lot of call signs. And we thought we were gonna blow up the ULS. And there was one instance where it didn't blow it up, it slowed it down apparently, and they had to go into the back end. But that, you're talking like 50,000 licenses.
Right.
So in our world,
No, no limit.
not happening. Good question.
What happens to the license if consummation isn't filed within the 180-day period?
The consent becomes ineffective, and I mean, until you file the consummation, nothing happens to the license in ULS or in the commission's mind. It still is held by the seller. And so if you don't file a consummation notification, then the consent just disappears. And if you decide you want to do something with it, you got to start
You
all
gotta
over.
start all over.
If the renewal is less than 30 days, can you still do assignments or transfers? The ownership already took place, not knowing they had to amend changes.
Say that question again.
Yeah, can you repeat that?
If the renewal is less than 30 days, can you still do an assignment or transfer? Is there a connection between renewal and assignment and transfer?
No, but so you can file renewals at any point, and our advice is if you're doing a transaction, assignment or transfer control, is, to get them on file. So they're at least pending. They can happen at the same time. They can both be pending at the same
Okay.
time. There's no FCC limitation with that. And, it's in your best interest, and whether you're on the selling side or the buying side, to make sure that it is on file and timely filed, so the license doesn't get canceled.
I think what I'm gleaning from the question is that there's already been a transfer, it hasn't been reported, and
Sure, you can file a renewal, but it just
But-
leaves that license in the same category as all your other licenses.
Yeah.
You know?
but they're separate transactions,
Yes,
Yes.
yes,
and you'd have to,
right.
you have to do one.
And if you file a renewal of a license and there's already been an unreported and unapproved assignment or transfer control of that license, that sticks with that call sign.
Right.
You don't cure it by filing a renewal. Commission doesn't know that this
So
transaction has happened.
you're gonna have to report to the commission as soon as you recognize that you're in error.
Yes.
Right.
Right.
And with any FCC form, I know we all take it for granted, the language that's on there, but there are general certifications
Right.
that say that everything is true
You're
and accurate
compliant.
to the best of
Yeah.
your knowledge, and that you're in compliance.
Right.
So when you're filing a renewal, if a transaction like that, like a sale of a license or a company has occurred in the past, you have to take that into consideration.
Right. You really can't make that certification.
Right.
Would the FCC fine you? And this is just my own question. If what you're certifying is that nothing has changed, but you know that something has, does that, I mean, you're perjuring yourself, if we were in a court. What is the FCC gonna do?
I mean,
Well, they're not gonna really know about it unless it's a big public company, but
well, I mean,
it still needs to be
I
disclosed.
think that the fines that the commission issue, I don't think that they would issue a separate fine for a misrepresentation.
Because you
for
signed a
something
renewal
like-
form.
Yeah, for
Right,
something like that. I mean, people do get fined for misrepresentation, but it tends to be a much more fundamental issues, about whether you should even be an FCC licensee or not. But I don't think they add on a fine.
Like you filed these 10 renewals,
Right.
2 years
I've
ago.
never
and-
seen them
right,
do that,
right,
but I
right.
can't say they wouldn't. I think they have authority to do it. I've just never seen them do it.
Right.
Okay.
Good
So-
question.
So the answer is you're going to need to go to the FCC as soon as you recognize that you need to.
No, that is certainly
Rectify.
my advice.
Yes.
Some clients follow it, others
Others don't.
All right. Here's another question. As we have reached out regarding upcoming renewals, it is only then that we are notified a licensee has passed away or retired, and the license is now being used by a family member who took over. So so what we're saying is that there could be quite a significant amount of time between the deceased and now the recognition that the assignment and transfer of control needs to be filed. In many cases, this occurred several years prior. Benefits or disadvantages of canceling the license and relicensing same frequencies under new individual versus going through an assignment of control. Please
Let me make
address.
sure I understand the question, because if you're looking at acquiring a license.
So that truly the question is, I think it's in order to avoid the fine. So let's say my grandfather
circumvent,
died 5
right.
years ago.
But I think
Yeah.
there are two different issues. And my question is, if the involuntary transfer, if the death occurred a number of years ago, and now the family realizes that they didn't do anything, what should they do? Versus,
Exactly.
I'm thinking of buying a company or the assets of a company, and in the course of doing due diligence on that, I discover that they didn't do what they should have done. In the
I would
latter case.
answer the first, answer the
Well, the first
former
one, the first one we've already answered. The answer is, you should
need to
come
file.
clean with the
No,
FCC.
the question is it better to just cancel the license and
And
refile or pay the fine?
my answer is, in the first situation where you're already where you're already involved with the license, and now you discover that you should have done something years ago, my advice as an FCC attorney is you should tell the commission and get it fixed up. If you're thinking of buying somebody and you discover that that has happened, I don't have any qualms about you just getting a new license. I think that's fine, because you had nothing to do with the failure to comply with the commission's rules. Now, do people just cancel old licenses and get new ones in those cases? In some instances, but you know what I would advise in those cases, and it doesn't necessarily avoid the fine. Once you discover that you're operating out of compliance with the rules, you need an STA. And in the STA, you can explain that, oh, gosh, there was a death and we failed to notify it. And so we need an STA until our permanent license is granted. I've not seen the commission issue fines in those cases. I can't say they won't. And again, it depends. If we're talking about, 2 call signs, I think they won't. I think they'll grant the STA. I think they'll grant the new application for permanent authority so you get a clean slate, and that they won't send it to the Enforcement Bureau. If it's a huge number of licenses, yeah, then they may view it differently. But certainly have had people do that. But now you've made the disclosure to the commission in the STA application. You have disclosed that there's an issue. And then I don't have any problem with you getting a new license.
If a client of mine has used a third-party repeater and the owner of the repeater died recently, and my client was the only user on that frequency, would it be advisable to file for a new license rather than work out a buyout and transfer of license?
So the client wasn't the licensee, they were just
True.
a customer?
They were just a customer and they were the only customer.
Well, heck, yeah, it's a lot cheaper to get a new
yeah.
license and a buyout.
Yeah.
So why not?
Yeah, that's easier.
Again, if you were not part of the violation, I don't have any qualms about anybody going in and getting a new license as long as you can get it. Now, it depends on the band and it depends on where you are. And sometimes you can get a new license and sometimes you can't. But as long as you are not part of the violation, it's fine.
Like a prime example is like the Part 22 licenses, those were
Yeah.
auctioned, so you can't
Can't get.
go
a
in and
license.
apply for it. That's a prime example of where you can't do it.
Okay. What happens if I bought companies throughout the years that held FCC licenses and there was never any filing of a transfer of control? Should we go back and file them now or start with future filings? You know, like when it comes time for renewal. Do,
You know, wearing our compliance hats is, you need to be forthright with the commission,
Yeah.
right?
And
Backtracking is also, it's a slippery slope.
yeah, I mean, I think. I have to advise you, make a disclosure to the commission. I'm not even sure how to answer that question because the current licensee, that's all correct. You're trying to correct things that happened before you took ownership of the licenses. I don't know. If it were up to me, I'd contact somebody at the FCC and say, hey, this is an issue.
Yeah,
What do you think we need to do?
yeah.
And I think if this person hadn't retired, this person would say, you can only go back so far in time. Just, you're doing everything right. It's prior ownership. But of course they could say, well, what kind of due diligence did you do that you didn't recognize it? But I think due diligence doesn't always disclose everything. So that's what I would do.
Liz and I do have hypothetical conversations with FCC staff
Oh, yeah.
to
All the time.
explain, as you can tell with a lot of our answers, things are complicated. And so the more complicated it is, we do reach out to FCC staff just to kind of gauge how we should file it. So when it comes in, it's not a surprise to them too.
all right. And given our time, I've got one more question. If somebody's got another one, I think we might be able to take one more after this one. Please. Oh, it just came in. So here's my question. Do you have to file if you're in a shared partnership, but the majority interest doesn't change? Like say I own 56% of the company and one of the other partners sells some or of his or hers, but my 56 stays the same. Do we have to file?
No, the magic number is 50.
It's 50.
Now, I hate to even raise this, but I will. There are instances where, what the commission is really looking for is who has control, who can they hold responsible if things go wrong? And percentage of ownership is the ultimate test, but there have been instances where a non-majority owner has such control over an organization through other mechanisms that they could be deemed to be in control. And so if that changes, if you turn over all hiring and financial responsibility and everything else to somebody who does not have the majority ownership in the entity, I think the commission could make an argument that there has been a transfer of control, but that's in the most extraordinary of circumstances and typically only in very large organizations. So I don't think that needs to be a concern for the people on this call.
Okay, and our final question. On
You said the
assignment,
last one was the final one.
sorry,
Go ahead.
on assignment of authorization or transfer of control, please define the roles of assigner and assignee when buying or selling the license.
So with assignments, the assignor is the current licensee that's on record in the ULS on the FCC license. That's the assignor. The assignee is the buyer who's buying the license from the licensee. So it's very defined roles. And the way that the ULS works is, when preparing the application is you go in as the licensee to do the licensee's portion. So it's licensee / assignor, they're one and the same. And then you hand it over in the ULS to the assignee FRN, and they complete their portion of the app, and then it goes back to the assignor/licensee to actually submit it to the commission. So there's two roles. It's licensee and it's like seller and buyer.
All right.
Transfer of control, you've got to look to see, you just have to look at the facts involved.
Right.
All right. That was all the questions. Thank you so much.
Okay, well, thanks everybody for participating.
Well, excellent. Thank you. These were all great questions. And I know this is very complicated, but we thought this was a great topic to cover. And if you have any follow-up questions, feel free to reach out to Liz or I. We'd be glad to help.
And you can forum shop and decide who's going to give you an answer you're going to like more.
I always put on going, I have a compliance hat I got to put on so.
I keep my compliance hat on all the time.
All the time. Thank you,
Thank you,
everybody.